On the polls this afternoon, Kumasi Metropolitan Assembly elects Amekomhene as new presiding member following protracted electoral impasse between the NDC and MPP supporters within the assembly. We bring you live updates from the region. Also this afternoon, political party executives in the country face possible prison terms after the Data Protection Commission filed complaints of non-compliance against them with the police service. We have details on that tonight. Also tonight we will catch up with the campaign trails. MPP and the NDC presidential candidates are on the road. We'll bring you updates on their campaigns. Stay with us all here on The Pulse. It's been weeks of standoff in the Kumasi Metropolitan Assembly area as officials there haggled over who was best suited to become a presiding member after many attempts and one time leading to violence with police called in to avert any bloodshed. Now we're hearing this afternoon that the Kumasi Metropolitan Assembly has finally managed to elect a new presiding member. My colleague Asare Mensah has been following this throughout the last few weeks. He joins us on the telephone line right now with the very latest on this. So who is this individual who has been elected the PM?
Well, we are talking about Nana Mensah Asare. He's the Amekomhene and a member of the Kumasi Traditional Council. He was one of the keys who was heard strongly advocating for the exit of the former mayor Kujobonsu. So this is who we are talking about.
And that little detail is so interesting, that the individual who, of course, spearheaded and, of course, supported the ousting of that former KMA boss is the one who everybody rallies around. What does that tell us?
In fact, if you read what happened at the hall today, it will tell you that there is a section of the members, specifically the government appointees, who are not happy with this development, though some members were invited by the Kumasi Traditional Council and they swore the King's Sacred Oath that they were going to go by what Mensah has said, that they should vote for Nana Mensah Asare. And so if you look at the voting pattern, this afternoon, for instance, when he was nominated, he picked up forms and they had to vote a yes or no on him. There were 22 no, and then there was 100 yes, which was coming from majority of the elected members. A number of the government appointees did not show up at all, and so you could find empty seats in there. I spoke with some of them who told me that, in fact, they feel bad about the fact that this is the same person who called for the exit of the mayor appointed by the president. And yes, so they have nominated him to stand there and they have to vote a yes for him to lead the assembly. And so some decided not to show up at all. Those who came said no to him. And so that is what has happened today.
These are interesting times indeed at the KMA. And tell me, to what extent was the Mensah Palace involved in this? Because already we're hearing rumors that he only managed to sail through because he had a backing of the Mensah Palace.
Exactly, Evans. This, I would say, is a total 100% decision taken or intervention made by the Kumasi Traditional Council. After some time, it was a deadlock, and so nobody was getting the 2/3 majority. It was between Abraham Bwadi and Michael Adusei. The same faction followed the two, and so we weren't getting anywhere without voting. And so there were some media condemnation at the fact that the chiefs, for instance, have stayed aloof and watched while this whole deadlock goes on, and that some people were even criticizing them that when the mayor was in there and they did not like him, they came ahead and spoke strongly. So why are they not speaking this time around? And so that is what led to the chiefs calling all the assembly members, and I understand that it was the elected members who went to meet the Kumasi Traditional Council. And so they spoke to them, made them swear the sacred oath of Otumfuo that they were going to go by whoever was nominated by the Kumasi Traditional Council as the presiding member. And so that's how come we had Nana Amakumhine. And so if you realize, the three representatives of Mensah at the General Assembly were replaced. And one of the people was Nana Amakumhine, and the others were Otumfuo's linguist himself, and then another chief. And so this was a 100% decision of the Kumasi Traditional Council. They said, go and vote for this person because we can see you are not getting a presiding member. We have chosen one for you. Go and elect him. So that is how come we have a presiding member today.
Okay, interesting times at the KMA right now. And so where is this individual now? Is he taking office immediately? Or there's a certain time he needs to be sworn in? I mean, and also I'm pretty curious to know, is this the first time we're going to have a traditional ruler as a presiding member for the KMA? No,
this will be, I think, about the third time because we've had Dumhine who contested first. He has held a position before. We had Asare Mensah. Also, it came to a time that it was the same fashion when it came to a deadlock. Asare Mensah was also brought in, and at a point in time, he also became presiding member. Now we have the Amakumhine, who is also becoming a presiding member for that. So this is not the first time. And to your other question, yes, he was sworn in today, just after the voting, which went 100 in favor of him, 22 no, and then 1 rejected. He was sworn in immediately by a high court judge who has sat through the proceedings waiting for the outcome. So he took office immediately. He even went ahead to adopt what language was to be used by the General Assembly. He went ahead to preside over a voting of the standing orders and acceptance of the standing orders of the Assembly. And so went ahead to adjourn the meeting and to tell the Assembly members that letters will be communicated to them on the next General Assembly. And so he has assumed office. He is the presiding member. He has taken office and he's working.
Now, Erastus, let's address the political undertones to this election impasse that we've seen unfold over the last few weeks. Is that still relevant with the election of the Amakumhine?
I've heard many assembly members speak about the fact that factionalism has been neutralized, and that with the election of Nana Amakumhine, the factionalism is neutralized. And in fact, when Nana spoke, he said that he's going to be a presiding member for all. He does not know followers of Nana Kofi Senya. He doesn't know followers of Kojo Bonsu. He doesn't know any government appointee, and he doesn't know elected members. He is going to be for all. That is what he said emphatically. And so there are people who think that with his election, that factionalism has been neutralized. But then it will interest you to know that when you speak with the assembly members themselves, the NDC, NPP faction has not been broken. It still exists. There are people who are jubilating and singing songs that suggest that their side has won, and in fact they have gotten victory that they deserve. And so you could still read the undertones there, but then at the General Assembly, I'm being told that they do not observe those things. When it comes to issues, they vote as it is. And so that is what going forward, the NPP NDC is still there, but then the factionalism in voting on issues will be neutralized.
Erastus, fantastic reporting there. We're grateful that you joined us, and we'll keep on following that story as and when we have fresh developments from the KMA. And if you just join us, the news this afternoon is Nana Amakumhine has been elected the presiding member for the KMA. Why this is important? We've seen that this has become one of the most acrimonious local elections ever. With one time we had scuffles, fisticuffs all-out violence at one of the election moments in the KMA. They've had several attempts to elect a PM. They have failed because of political undertones, but because of disagreements among members of the assembly. Finally, they have a presiding member. And we also know that the fact that they didn't have a presiding member affected development projects and the running of the second largest city in the country, the Kumasi metropolitan area, to the point that we reported about filth building up uncollected, again, as they haggled over who becomes a presiding member. And now that they have a presiding member, Kumasi can be taken care of. And it's a unanimous, not a unanimous, it's an overwhelming mandate he secured. 100 people voting yes to him, as against just 22 people saying no to him. A pretty significant victory he's won there, seeing that every other nominee before him had fallen by the wayside because he's been rejected. We'll keep an eye on the story as it unfolds. But this afternoon on the pulse, we want to quickly shift attention to politics, because we have a lot happening on the political front this afternoon. The PPP flag bearer, Dr. Papa Kwesi Yindum, says he's resuming his campaign for the 2016 general elections as he employs various strategies to fight back against his disqualification from the race. Dr. Yindum, along with 11 others, were disqualified for failing to meet the requirements for filing a presidential nomination form. The EC has further referred the said infractions in their nomination forms to the police for investigation and prosecution. But Dr. Yindum has appeared on Joy FM Super Morning Show, mounting strong criticism of the commission for his disqualification. He spoke to host Inshirado.
And all that we're trying to do is just, make our case, and let people know that indeed there's been selective administration of the laws.
In the event that you go to court and the EC's decision is upheld, what next? What would you do in that hypothetical situation?
Well, I'm someone who believes in the law. So should we go to court, and a court of law, says that everyone. I'm not stopping. And I want to tell our parliamentary candidates, starting this evening, I am campaigning. I'm going to be with them every step of the way. Whether I'm on the ballot or not, we have something wonderful to sell to the people of the Republic of Ghana, and we'll continue to do so. We need PPP people in parliament, especially, even, yes, I'm president, that is a bonus. But in parliament, because you see, this 1992 constitution we have, it is a travesty, It is an imposition on the Ghanaian public. It is something we must change. We must reduce the powers of the president. We must let the DCEs be elected by the people. So democracy, real democracy, goes to the grassroots. The Attorney General's office, there should be a separation. The Minister of Justice should be the president's lawyer. The Attorney General and the independent prosecutor's office should be the people's lawyer, so we can fight corruption more effectively. That can be better done, initiated from Parliament. We want PPP MPs there to help push this agenda forward, so a much more stronger nation can arise. So we are going to continue with enthusiasm to campaign to Ghanaians, and I want people to know that this matter we're talking about, it applies to Papa Kwesi Yindum and his presidential ambitions alone. It does not apply to all of those parliamentary candidates that PPP has all over, which is why tonight we're going to Ayawasu, West Wogon. Tomorrow we're in the Volta region. We're going to Akachi, we're going to Keta, we're going to Aulon, will continue to campaign with enthusiasm and let people understand that something better, something bigger, bright ideas, and a more prosperous Ghana is coming through the Progressive People's Party. And let me just tell you, I want people to not forget that, number one, the EC has set rules on audited accounts, on expenditure returns, and that some parties chose to respond and comply, including the PPP. Others didn't, and they have not been disqualified. That there was a requirement to declare assets. Papa Kwesi Indom did. Others did not. And those who did not have been accepted. Okay, they've been accepted. That other people were told that they had some things to deal with and were given the opportunity to satisfy the requirements after the nomination time came to a close. And they were given, if you will, special dispensation. Why did Papa Kwesi Indom not given that same opportunity?
Okay.
That's selective administration of the law. That is what we are against.
So he had the Papa Kwesi Indom, but he's not the only disqualified candidate on the EC's throats. Several others in the same situation are also challenging the Electoral Commission. We'll be speaking to the Electoral Commission spokesperson, deputy spokesperson shortly. But in the last few minutes, we have another development on this very matter, exclusively here on the polls that I want to bring to your attention right now. We have secured documents from the Electoral Commission authored by their lawyers responding to the threat of legal suit from lawyers from Nana Akuno-Adjumani Rawlings, former First Lady of the NDP. They had originally written to the EC questioning the basis of the disqualification, also questioning the authority to disqualify them on this all-important subject of whether or not Nana Akuno-Adjumani Rawlings can run for president this year or not. Well, this afternoon, the EC has managed to get their lawyers to also write back to Nana Akuno-Adjumani Rawlings' lawyers. Remember that in that original statement written from Nana Akuno-Adjumani Rawlings' lawyers, they had given the EC some ultimatum, an ultimatum of about 24 hours for them to rescind the decision or they'll proceed to court. From what we are seeing in these documents, the EC is sticking to its guns and of course, not budging at all. I've just been joined by my colleague, Favor Nunu. He's been reading through the documents, joins me with details, and this is fascinating stuff. The EC is not ducking at all. They're taking this frontally and they're fighting back.
Indeed, Evans. Essentially, so in this letter that is written by Thaddeus Sori, who's the EC's lawyer, to address to HA, the Benji Angel Lecha and Ankuma law firms. Basically, they're saying that the position of the NDP's lawyers asking that or suggesting that the EC does not have the capacity to disqualify their candidate is wrong. And they have established a few points here that I'll read through to you. It says, our response to your argument that our client has no power to proceed in the manner in which it did. Our reading of the rules regulating the submission of nomination papers for purposes of contesting the presidential elections confirms that the submission of nomination forms does not result in the automatic acceptance of such forms by our client. So that in spite of the fact that one may turn in your nomination forms, it doesn't automatically mean that you
once you submit,
you go through. Then you have to go
now,
through.
if you go,
process that
he needs to go through, because you must recall that the lawyer for Nana Akuno-Adjumani Rawlings had indicated that the EC didn't have the powers to disqualify their clients. And if you go on, they state that our understanding of the rules, and they were referring to the rules governing the submission and acceptance of the nomination forms.
Which is captured in the CI 94.
True. Refer above is that the returning officer's obligation to give candidates an opportunity to make amendments or any alteration necessary to ensure that their forms comply with the requirements of law and the candidate's corresponding right to an opportunity to make such necessary amendments and alterations is conditional upon such obligation and correlative right being exercised and enjoyed respectively within the stipulated nomination period. And that's one of the most contentious bits of this. What else are they saying in this letter?
Well, and so they continue to argue that where the circumstances of a case render it impossible and to make the necessary amendments or alterations for purposes of ensuring that a candidate's nomination complies with the law, the effect is that the candidate's nomination form does not comply with the requirements of law regulating their nominations, resulting in non-compliance. And when it happens in that way, it says that where a candidate fails to comply with the regulations, the returning officer shall consider the nomination paper of the candidate as invalid and shall endorse and sign the nomination paper for the reasons and cite the reasons for signing against that. And then he says you then inform the commission. And finally, the candidate is informed about
There's an important point they make subsequent to this point they just raised, which is the fact that, I mean, prior to this, the conversation has been around, did the EC give them enough time? Did they even alert them to the fact that there were errors? Did they give them enough time to correct these errors? Now, if you read the EC's letter here, they say the rule is emphatic that the consequences of the failure to effect the alterations and amendments within, and this is highlighted, within the stipulated nomination period, is that the candidate nomination is invalid.
Yes.
It goes on to say, no provision is made for extension of time in CI 94. In other words, they were giving the time 28th, 29th to submit the form.
29th, 30th
29th to submit the form.
But you need to be able to go ahead and submit before this time if you think you're able to do so. And so what the EC's explanation here is that, fine, the 29th and 30th is not binding on every person or every candidate to say, on these days, you can then submit. You can come ahead on the 15th. You can come earlier. And so you can go through the process of going through all of the corrections that there is to.
And the point they're making here essentially is that if you want to correct, you have to make the corrections within that time before the expiration of the close-up day on the 30th. But there's a further interesting point they make. They say, our client's instruction, this is the part we've been waiting to hear from the EC about. What exactly did they do once they received the forms once they received the forms from the National. They say, our client's instruction to us are that in the particular case of your clients, upon presentation of their nomination papers, they were given the opportunity prescribed by Regulation 92 CI 94 to make the necessary amendments and alterations to correct those errors, which the returning officer was capable of detecting without further checks, and your clients accordingly effected the appropriate amendments and alterations. I mean, that's interesting.
And so they were given the opportunity then.
But note the point he makes. Those alterations and errors that were detected were only those which the returning officer was capable of detecting without further checks.
Okay.
In other words, as at the time that if he didn't spot the issue about the signatures, the duplication of the subscribers, etc. at that time, he wouldn't have alerted them to that error until after, when he had done further checks. So it presumes, and we need to speak to the lawyers to understand this. It only suggests to me at this point, and we're open for correction here because we're just reading the face of it, that these additional grounds that led to the disqualification only came up. The return officer detected it after the expiration of the 30th.
Done the corrections. And
so that led to that disqualification, which
which means that you remember in the other side, they said that it is not the responsibility per se of the commission to necessarily point out these corrections. It can be exercised based on the EC's decision. And so if the EC did come forward and then point out mistakes to you, it then is the responsibility of whoever this candidate is to go through it and examine if there are other errors to which they would seek corrections to within the stipulated time. And if they are unable to identify it and the EC goes ahead with its processes, then if there are errors that are found, you may find yourself.
Finally, I see another paragraph that's interesting. It says, with regard to the non-compliant errors in respect of which our client expressed its inability to accept your client's nomination papers, however, we have been instructed by a client that it was impossible to comply with the strict time period specified by the rules within which your clients are by law permitted to amend or alter their nomination papers to comply with the requirements of the law regulating same, especially that your clients presented their nomination papers a day to the expiry of the nomination period, although your clients and all candidates were urged to submit their nomination papers as early as possible. So in other words, they submitted it on the 29th. Giving the EC 24 hours to spot and call them back to
all
check. In effect, in their regard, we must point out that our client does not take over responsibility for correctly filing out the nomination papers of the candidates only because the law requires the returning officer to draw their attention to statutory non-compliance. And so this is interesting. And so, of course, these are early days.
And there are arguments. There are also those parts about whether the EC has the capacity to take someone out of the voters register on the basis that such individual has registered twice. And so that is also captured on other pages. And when you read it, it says that in the first place, let's see if it's here, but in reading it, what the EC then says in this response is that the argument by the lawyers of the NDP that they cannot, as a commission, take out names of persons or determine that one person has actually been on a register twice and therefore invalid and cannot vouch for a candidate is wrong. The EC is then saying that we have the capacity, it lies within our authority to determine that a candidate who is registered twice in our register cannot vouch for another. The issue about the legalities, the criminalities, will then be handled by the court. So it is not our responsibility, or it's not the responsibility of the court to determine that a candidate or an electorate is illegally registered on our register. So that's the point that the EC is making. It is our right, it lies in our capacity to determine whether a candidate or a registered applicant cannot be on the register. But in the event that this person is found out to have appeared twice, it is our responsibility to move the person to the police. When the person goes to the police or the court, that is handled as a criminal case. And we don't mix the two.
Which is what we like to see now.
That's what's going to happen.
Favor, thank you very much. Thank you very much for that insight. But Nana Ajenim Boateng of the United Front Party has written to the EC challenging the disqualification. Frankly, Kwabena Asamoah is his lawyer, and he joins us on the line for more on this. Thank you, sir, for the time. So tell me, on what basis are you challenging the disqualification?
Hello?
Can you hear me, sir?
Yes, I can. My client has breached Aggression 7.4 of CI 94, which frowns upon a subscriber supporting the nominations of two different presidential nominees. Our contention here is that the sins of such a subscriber should not be visited on our client for two reasons. He has no way of controlling the conduct or behavior of a subscriber. Our client also has no way of knowing that his subscriber has subscribed for some other person. You see, in a situation like this, we should be looking more at the spirit of the law rather than the letter. Why is it necessary that a presidential nominee must have two subscribers from each district? This is to ensure a national character for the party. So, strictly speaking, this is not a violation of any law that can disqualify a person, although that is what the law says. So, we are of the view that if a situation like this arises, the presidential nominee should be called upon, given a time, to go and rectify such an error. It looks more like an error than an actual breach of the law. Now, the situation here is this. Some mischievous person can use this law to create some very, very serious problems for this country. For every political party, a presidential nominee has his own opponents, because there are others who also want to get to that position. What if a high-ranking officer of the party subscribes to the nominee of the party's presidential candidate and subsequently subscribes to that of another person, just to get the presidential nominee disqualified? If this happens in the NDC or the NPP, how can this nation handle it? It is easier when it happens to a minority party. It is easier when we look at it from the comfort of our homes and say, oh, a law has been breached. But we should be looking at what can happen in the future. And I think that a strict interpretation of the law will not serve the desired purpose for the framers of the law. So we are prevailing upon the Electoral Commission that it is not too late. Call our client, give him a time frame, let him rectify that error, and let them move on.
Well, tell you what, as we speak on this matter regarding your client, the EC is responding to a similar case when it comes to the NDP, and their position is clear that they didn't breach any rules. They're not going to give you any chance to rectify. It's done, it's dusted. You have to go to court. So that is the emphatic position of the EC. Nothing you do will change your minds now. They've written this emphatically in the document I have in my hand here, arguing legally that they've done the right thing. It's only the courts that can overturn what they've decided.
That position is unfortunate. You see, society is dynamic. And in all democratic countries, there are teething problems in the growing process. Teething problems that we need to look at soberly. Teething problems that we need to resolve now so as to avert a future upheaval. Well, she is on the seat, and this is the way she is looking at it. I think such a combative stance doesn't do our democracy any good. It doesn't. And even in the courts, we have alternate dispute resolutions. If people sit down and come up with the idea that it is not every suit that must travel the full trial, why can't the EC adopt similar position? Rigidity has never helped the cause of any country. And it's unfortunate that Mrs. Charlotte Osei is taking that stand.
It begs the question, what are you going to do about it?
Well, I need to talk to my client in respect of this. But I told him that, well, that is the strict interpretation of the law. She could have interpreted it loosely. If she goes by the strict application, so be it. But I need to talk to my client in respect of what we should do to the reaction or the stance that has been taken by the Electoral Commission.
Thank you, sir, for your time here on The Pulse. Now,
you're welcome, sir.
Let's stay with this story a while longer because it's just developing as the hour goes by. A presidential candidate for the Independent People's Party, Kofi Apalu, held a news conference this morning on his next line of action. Here are excerpts.
EC have disqualified me to contest the 2016 elections on flimsy excuse. The excuses that they provided are stated here. They are saying that 3 subscribers have also gone to subscribe another candidate. So as a party, because we have our database, we know where they live, we have their contact addresses and what have you. We had to quickly call our people and find out from them whether they have signed for another candidate apart from us, and true and behold, they are saying no, they haven't. So this morning we decided to call you, the media, so that you'll be here, so that you see it yourself, and then you can take the matter to the whole world for them to know that the EC is not being fair to me and also to IPP. So on the list we have Alfred Yovoglo. I want you, if he is here, I want him to come and show us his voter's ID card so that the media you can compare. Mr. Alfred Yovoglo, please.
Alfred.
Yeah. Come with your on this flimsy excuse. And the whole world, he has gone ahead without even inviting me or EC. We provided the EC not only their voters ID, we gave the EC their current address. So if EC wanted to know the truth, what EC should have done is to call them and find out from them, did you sign for Mr. Apalu? Are you okay? Or any other person? EC did not do that. And EC went ahead to disqualify me on the grounds that these people have gone to sign for another candidate. But I want to ask them whether they have signed for me and any other candidate. I want you to ask them.
The point is that EC cannot.
No, please, we don't want to go to that. I want.
No, so the police.
So that's Mr. Palu there.